Hello, my name is Paul Cooperrider. I am the Technology Commercialization Program Manager for the Idaho SBDC. I'm here today to talk to you about steps that you can take to develop a viable IP management strategy. And the first thing you may ask as a client is, why should I care about IP management? Well, you should care because a properly managed IP portfolio can provide you better revenue, better profits, and better valuations, and ultimately lead to success for your company. So how does an IP management strategy deliver these benefits? It does this primarily by two routes. One is by providing monetization potential, and there are multiple ways that we will explore to monetize your IP. The second way is as a basis for attracting investment. Investors will often place value on a company's ability to monetize their IP. Let's look at some examples for monetizing IP and attracting investment. The first example, or the first way in which you can monetize IP, is providing a durable competitive advantage in creating and delivering your value proposition. By this, I mean that you can protect and enhance your revenue streams and your profit margins. Typically, this is done by providing higher incremental margins or reduced cost of goods sold. Another way to monetize your IP is to leverage it for alliances and partnerships. And finally, you can monetize your IP by licensing it or outright selling it. When you think of attracting investment, investors will often look at the valuation of the IP in the portfolio. Valuation of that IP portfolio is a critical part of the process in evaluating for any funding rounds, and is especially critical for valuation for any exit event, such as an M&A, an IPO, or liquidation. So let's look at some examples for monetization of IP. First, let's look at protecting and enhancing revenue streams and profit margins. In this case, Company A had a patent on CPU busbar architecture. They became the de facto sole source supplier and were thus able to demand a higher price to their customers. Conversely, they were able to license and leverage this technology to their suppliers, and as a result, were able to get a lower cost of goods sold from their suppliers. So they were able to increase not only their top line revenue, but also increase their gross margins. An example of licensing, Qualcomm derives most of its revenue from licensing. In 2016, Qualcomm derived revenue of $7.6 billion, and of that, $6.5 billion was pure profit. From a selling standpoint, the same company A from above sold their patent portfolio of 50 patents for $100 million in an exit. In the example of alliances and partnerships, Company B had a portfolio of patents that were included in an industry standard for a family of storage products. Through this portfolio, they were able to influence the standards body on the formats that would be used in the storage products, and also had a first mover advantage in the supply chain for creating that necessary format. In terms of valuation for an IP portfolio, in the first example, Company C was looking to buy a software company for $5 million. They found out that the seller did not own the copyrights to the code, and consequently, the deal cratered. Conversely, a properly protected and recognized IP portfolio can boost the valuation by 5x to 7x and affect the exit valuation by millions of dollars. And this is from an IP attorney in Idaho that has a healthy practice. So now that we've talked about how IP can provide those benefits, you may ask, well, how do I manage my IP? Within the Idaho SBDC, we look at IP management in the context of the business model canvas and lean launchpad processes, which we use to guide and consult our clients in general. And as a quick refresher, on the right side of the canvas, what you want to demonstrate is that you have product market fit. That is, that you have identified customer segments that have pains or gains that need to be met, and that you have demonstrated that you have a value proposition that can meet those pains or gains. What we have shown in the previous slides is how IP is a key resource to help create and deliver your value proposition. We will now talk about the key activities needed to create and protect your IP. One of the key activities that you will need to do is to explore your freedom to operate. You will need to also inventory the IP in your portfolio, identify what gaps in your portfolio relative to what's needed to protect that creation and value proposition, or creation and delivery of your value proposition, and finally determine how you're going to own that necessary IP, either through developing it or acquiring it. Let's first take a look at freedom to operate. The question you should be asking is, does your company have the freedom to operate in your market segment or segments? You'll need to understand your competitors' IP, their patents, trademarks, copyrights, domain names, etc. To do this, you may need to do a preliminary search for landscaping using tools from the U.S. Patent and Trademark Office or online resources like Free Patents Online or Google Patents. You can also utilize the resources of U of Idaho's Small Business Legal Clinic. The U of I Small Business Legal Clinic provides trademarking and patent pro bono programs to help you in understanding whether you have freedom to operate. The next thing to do is to inventory your IP. Assuming that you have identified that you have the rights to operate in the market segments, or that you can exploit your market segments, you'll need to inventory your IP. You'll need to assess the strength of the IP in protecting your value proposition. One of the first things you'll want to do is to understand how easy is it to work around your particular implementation. If you find that it may be relatively easy for a competitor to work around your particular implementation, you may decide not to patent that, since it would be relatively easy for a competitor to make a few changes and provide a similar solution to the customer without violating your patent. You'll also need to determine how easy it is to reverse engineer your solution. If you find that it is difficult, relatively difficult, to reverse engineer your solution, you may decide to either patent only a little bit of it or none at all, and in fact keep everything as a trade secret as a way of erecting barriers to entry. Should you decide to go the route of trade secrets, you will need to exercise all the processes necessary, essentially, to protect those trade secrets as such and be recognized as such in a court of law. We'll talk a little bit about those later. If you decide that patents, trade secrets, and copyrights are insufficient to protect your value proposition, you may go the route of branding. You may choose to establish your brand identity as a way to protect your value proposition. Particularly, that means that you need to identify the portfolio of trademarks, trade dress, and domain names necessary to protect your source identifier or your brand. And obviously, this is integral with your go-to-market strategy. Once you've inventoried your IP, you'll then need to identify the gaps relative to what's needed to protect the creation and delivery of your value proposition. And the question you should be asking is, where does my company need to have IP that it doesn't have today? And again, you may need to do some IP landscaping to understand whether the IP can be created to fill that gap or whether you need to acquire it. So you'll be asking yourself, what's the most effective way to own that IP? Typically, there are two channels. One is you develop it either through building or creating it, or you acquire it through a license or cross-license. Should you decide to build and create IP, i.e. through patenting, you need to understand the timelines around the patenting process. You need to understand ideas or concepts like first to file, which the US now is aligned to the rest of the world in terms of that concept. You'll also need to understand that you only have 12 months from the first public disclosure before you need to file a non-provisional application to the USPTO. And you'll also need to understand the maintenance fees and timelines for those fees should you get awarded a patent. If you choose to go to other countries, you'll need to decide whether you want to patent in other countries. You'll need to understand market entry and timing issues relative to patent protection and market introduction. You'll need to understand the costs and timelines of international patents, looking at the Patent Cooperation Treaty, the PCT, and you should understand the role of the USPTO and the World Intellectual Property Organization, or WIPO. Should you develop trade secrets, you'll need to demonstrate that you have the proper behaviors to protect those trade secrets as such. You'll need to demonstrate that you have the proper NDAs, the proper employment agreements, and you'll need to ensure that you have both physically and digitally secured your documents. Should you decide to use the branding approach to protect your value proposition, you'll need to establish clear brand identity through trademarks, trade dress, domain names, etc. You need to understand the difference between trademark and trade dress, and you need to understand the difference between the TM mark and the R. The other thing you'll want to do is to make sure that you create a moat around your digital presence in the internet. Domain names are relatively inexpensive to get, and it is our recommendation that you consider creating a moat, getting multiple domain names to protect your source identifier. The last thing you want to do is to have a competitor creating confusion in the marketplace by having your same name but using .net or .us instead of .com. And furthermore, there are people out there that could negatively target your company by getting domain names such as applesucks.com. That's a true thing. Similarly, if you take the approach to going international with your brand, you'll have to understand market entry and timing and work with WIPO in terms of making sure that your branding is appropriate in the nations that you're going to be entering. If you choose to license and cross-license, you'll need to understand what the IP landscape looks like, and in particular, who owns the rights to the IP that you need. You'll need to decide whether you will directly license or sublicense, and if your IP war chest is big enough to even entertain the idea of cross-licensing. As you create licensing agreements, there are certain things that you'll need to take into consideration. You'll need to understand concepts like background and foreground IP rights. The background IP is IP that your company owns independent of any collaboration where IP rights are involved with another entity. Foreground rights are IP rights that are conferred on the entities involved in any collaboration once the collaboration is set up. You'll need to understand terms like field of use, the territory over which the rights are confirmed, the duration of the licensing agreement, the rates that will be used, such as the licensing rate or royalty rates, etc. And finally, you'll need to be familiar with concepts such as warranty and indemnity in your licensing agreement. Now, we talked about the key activities to protect and create and protect IP. Now we'll briefly talk about the key partners. Key partners briefly can be bucketed into 4 categories. The first category are your IP attorneys, the patent agents, your IP clinics. These are people that will prosecute your patents or your copyright, trademark submissions, etc. The second grouping consists of organizations such as the U.S. Patent Trademark Office, U.S. Copyright Office, and WIPO. These are organizations that will either confer to you the right or act as coordinating bodies to ensure that the proper institutions are reached in coordinating those awards. The third group are consultants and mentors, including the SBDC, with experience in managing IP and are not attorneys or agents. And finally, the last group are investors. Since many investors are interested in IP in high-tech companies or in tech companies because of their ability to monetize that IP and the impact that they have on the valuation of the company. That concludes my webinar on IP management strategy. I thank you, and if you have further questions, don't hesitate to contact your local SBDC office, or you can contact me at paulcooperrider@boisestate.edu.